Good afternoon. It's my pleasure to introduce the Honourable Chief Justice Debbie Mortimer, the 5th Chief Justice of the Federal Court of Australia and the first female to hold that position in the court's almost 50-year history. The Chief Justice was appointed to that position in 2023 after having been a judge of this court since 2013. That appointment reflects Her Honour's leadership and eminence in a legal career involving many years of public service and commitment to the administration of justice within the Australian community. This afternoon, Chief Justice Mortimer joins us remotely to officially welcome our distinguished panellists and guests to this, the first seminar in the court's 50th anniversary seminar series. Please join me in welcoming the Chief Justice to the virtual podium.
Thank you, Justice Futrell. Welcome and good evening to colleagues, members of the profession and distinguished guests who are joining us across registries and online, but particularly in Sydney. I'm speaking to you tonight from the country of the Eastern Kulin Nation people, and it's a pleasure to be here. This seminar marks the first official event in the Federal Court's 50th anniversary celebrations and the first of the National Practice Area Seminar Series. 12 seminars will be presented over the next 12 months as part of that series. The 50th anniversary provides an opportunity to reflect on the court's history and development and its contemporary role in the administration of justice in Australia. It is particularly fitting to begin the NPA seminar series with one of our distinguished panel members being the architect of the court's National Court Framework and the National Practice Areas, the Honourable James Allsop AC. As Chief Justice, James introduced the National Practice Area system as part of the broader National Court Framework reforms. At a conference marking the court's 40th anniversary, Chief Justice Allsop said that the aim of the NPA system was, and I quote, to see the operation of the court focus on development of the deep skill of its judges and registrars in what are in some, but not all respects, very specialised areas of practice. The NPA system remains foundational to how the court organises its work, and I pay tribute to the Honourable James Allsop for developing this foundation. I also want to thank tonight Justice Elizabeth Raper and Justice Erin Longbottom for being the inspirations behind this seminar series and for working with all the national coordinating judges to bring this program together. And in relation to tonight's seminar, I particularly thank Justice Sarah Derrington and Justice Michael Futrell as the current national coordinating judges for the Admiralty and Maritime NPA for their work in developing this seminar and in arranging such an outstanding panel. The seminar series is an important part of marking the court's first 50 years, not only by reflecting on our history, but by engaging with the areas of practice that define our work and continue to shape it. Thank you all for being part of the occasion, and I'm looking forward to the seminar. Thank you.
Well, good evening, everybody, and thank you all for coming. It's an excellent turnout, as I would expect from the maritime and admiralty profession, particularly given the speakers we have tonight. Although it's not really correct to call them speakers, they are going to be conversationalists. Now, the Honourable Justice James Allsop AC is known to most of you as one of Australia's most respected jurists and legal thinkers. He was the immediate former Chief Justice of this court and is widely recognised for his distinguished service to the law, his expertise in commercial, maritime, insolvency and international legal matters. Since retiring from the court, he has continued his professional work as a mediator and legal practitioner, as an arbitrator, He continues to contribute to scholarship, education and professional dialogue, and now spends much more time with his chooks, his dogs and his grandchildren. Martin Davies is the Niels F. Johnson Chair in Maritime Law at Tulane University Law School in New Orleans, one of now the stellar universities that teaches maritime law around the world. It has, I think, taken the crown away from nearly every other institution, perhaps with the exception of Singapore. He is an internationally recognised academic specialising in maritime and commercial law, and I'm sure that nearly everyone in this room has had recourse to Davis and Dickey's at some point in their career. He has taught at leading universities in Australia, the United States, and really around the world, and is widely published in the fields of shipping law, carriage of goods, and Admiralty law. One of his great talents is making complex maritime legal issues accessible and relevant to practitioners and students alike. And this is no doubt because of his extensive training in theatre. And the maritime law world's gain was Hollywood's loss. I ask that you make them both welcome. Now, to start with, some of you will have noticed there's an object sitting in the middle of the bar table. Mr. Street this morning complained that it was not on the bench before me, hearing an Admiralty matter. But Professor Davis, what's the purpose of this object?
The oar mace is a symbol of the fact that the court is sitting in Admiralty, which I guess we are this evening. Historically, the courts in England would sit with a mace, which was a fairly sort of crude representation of the authority of the court, like you better behave yourselves out there because there is this thing that can club you into submission if you don't, right? So it was a symbol of the court's authority. And when the courts began to sit in Admiralty, the mace that they used was an oar mace, which was a different form, as you can see, from the mace that was used in common law proceedings. And so the oar mace has ever since then been a symbol of the sitting of the court in the Admiralty jurisdiction. So courts in the United States, in the United Kingdom, and Australia and Singapore all have oar maces when sitting in Admiralty.
James, what's maritime law?
Okay, how long have you got? Right.
This is the topic we'll start and not finish. But most of the things we'll be talking about tonight will in some fashion illustrate the conception that I'm about to try and begin clearly. Maritime law, many of you, this is a New South Wales audience, so most of you will have heard of the fusion fallacy wars that some of the greatest textbook writers and thinkers in equity declared against Lord Diplock and his colleagues in the common law bar and judiciary of England in the 1970s, because they quite wrongly, there's my allegiance, they quite wrongly thought that equity no longer existed. One of my erstwhile colleagues, who was a Victorian judge, who shall go nameless, once said to me, I think he was joking, I'm not so sure, that he said equity was a figment of the New South Wales bar's imagination. To which I said to him, if I wasn't otherwise so admiring of his skills, I would simply tell him that was one of the crassest, the most stupid legal propositions I'd ever heard from anyone. Because they are different. They came from different sources. One, and you only have to read Jennings' case and the extract from the Juliana and those masters of equity, Dixon and Kitto, together with McKinnon, talk about the different sources and the different framework and focus of common law and equity. They were different principles. One ultimately came from a religious source, although it was secularized long ago, of notions of surprise, fraud, conscionability, and the like. And the other reduced things to small questions and answered them because a jury had to deal with it. And that war, that defence of equity by Montgomery Lehane and the like, was also a defence of maritime law, because in the same cases, Lord Diplock said, and maritime law no longer exists because we've taken it out of the hands of the civilian courts, which it was in, and put it in the hands of the courts after the 1873 merger of procedure. The fact is, maritime law, it's easy, it's actually quite straightforward to conceive why it is different and why it is not special, but why it's just different. Because it's a branch, it's a separate branch of the general law. It can be seen as such because it's the law of out there, past the low water mark. And it's the law not of a place or a society or a people. It's the law of an activity that's been carried on for millennia and is still carried. It's still the most important. Still, most of international trade is done this way. And it's the law of an activity. It has common principles. And if you conceive of it that way and recognise that it's of the first order of importance to understand that it's the law of an activity, you will then understand why Wigmore, in one of his wonderful historical books, talked of the 16 legal systems of the world. And those 16 systems were of place, China, Europe, Greece. They were of religion, and they had and one of activity, and that was maritime law, a world legal system. And that's why it's important, because if you think about maritime law as just Australian maritime law or English maritime law or United States maritime law, and put salvage in a book about unjust enrichment, not that that's a bad thing, and then start conceiving about salvage as, oh, that's contract and unjust enrichment. No, it isn't. I mean, of course it's got contract in it. Of course it's got restitution and unjust enrichment. But it's about rewarding people in a dangerous place. And if you conceive of the activity is one in which the participants are constantly surrounded by their death at sea. And these aren't just colourful expressions, they form the framework of how people think about principles and rules. And I'll hand over to Martin in a minute. And the other thing as lawyers to think about, it's a constitutional conception in the United States, and we'll talk about it a bit later, especially in the United States. And it could have been a constitutional conception here if it hadn't been, and if it wasn't for our imperial subservience as colonies. So that's my introduction as to why it's what it is and why it's separate as a branch, not in a little box not being affected by anything else, but intertwined with its own international and maritime sources that speak to it. And I'll say a few more things, but I'll leave it to Martin.
Well, no, I mean, predictably, I agree with that. One of the foundational things about maritime law is its transnational nature.
Yeah.
Right? But I guess I would like to ask you a question in the light of what you just said, which is one of the big divides in legal terms in the world is between common law systems and civil law systems, and yet, do you think that maritime law transcends that divide between common law and civil law?
Well, in a sense it does, because its roots and history are civilian in the common law system as well as the civil law system. Its notions of transforming equity and civilian concepts of attachment that died out in common law countries except for the United States.
South Africa.
And South Africa, yeah. Well, with that mixed system. It's got a rich civilian common law, a deep equitable notions of seamen as wards of the Admiralty Court, because they're so often put upon and taken advantage of, and they still are. And notions of just fairness. And there isn't a real divide, I don't think, although there is in terms of how common lawyers approach things. But the conventions on salvage and arrest and maritime lands all involve compromise between civilian systems and common law systems.
I mean, predictably, again, I agree that the international uniformity. I mean, uniformity is always like this impossible goal to achieve, because it's never going to be entirely uniform internationally. But the extent of international uniformity in maritime law is one of the very distinctive aspects of it, because the way I express it to my students is, it just makes obvious sense that you wouldn't want the law affecting the voyage of a ship to change from one end of the voyage to the other.
Yeah.
Right?
And there's uniformity and there's harmony, and they're two different. They play different roles.
Mm-hmm.
Harmony, by harmony, I mean sufficiently harmonious to be recognisable to the master or the practitioner. Oh, where are we? We're here. Right. I know what they'll do. This will be the rule, or here, that will be the rule. And we'll come back to that. But that notion of uniformity through maritime convention in particular, I mean, take salvage. The big debate in 1911 before was reward or assistance. Was it the French? It was closer to unjust enrichment. We gave assistance, and we should be paid for it. And we took risks, and we gave assistance. The ship foundered, and all the cargo was lost, but we tried. We had all these days' work. Shouldn't we be paid for it? The owner should pay us for this. No. The English, no gain, no. If it's unsuccessful, and that's why you're rewarded, because when you are successful, you're rewarded. And it's not mere assistance, it's reward and encouragement. So the next person will go, oh, no. We'll go, I'll be in there, and it becomes a profession. But harmony, I mean, we have a worldwide maritime security regime that turns the water of unsecured claims into the wine of secured claims, as long as they're maritime claims and as long as the property is maritime. And whether it's through liens or unsecured in personam claims being enforced by attachment, maritime attachment, or statutory attachment, or in rem claims. You have this system all around the world where different people have different liens, different people have different orders of priorities, but everyone knows what the system is.
Mhm.
And it works, and to try and get a uniform is a chimera.
Mm.
But as long as everyone understands what the game is in different places, then it works harmoniously and justly for international commerce. Because
Martin, you've expressed some thoughts about whether there is still a need for that special jurisdiction.
Well, yes. I mean, when the ALRC wrote its report, Civil Admiralty Jurisdiction, they began with the question, like, should there still be a special Admiralty jurisdiction? I don't know how seriously they considered the question, to be honest. I mean, I think it was just, you know, the appropriate thing for a law reform body to be doing when they've been asked to consider, you know, the reform of the Admiralty jurisdiction. Well, should we be having it at all? But if we didn't, then there would have to be something in its place, because there would have to be something equivalent to the civil law systems. The French. I enjoyed how James became all French when he was talking about assistance, right? So I'm going to go saisie conservatoire, right? But the French notion of being able to establish jurisdiction by seizing property is I think an unavoidable part of the way that maritime commerce works, right?
Yeah.
Because without that, it will be next to impossible to establish jurisdiction over an absent defendant.
that's right.
And so there has to be some form of establishing jurisdiction
Well, if you've
by seizing property.
That's
And if it weren't the Admiralty jurisdiction, it would have to be something else.
And I mean, I don't know how many. Leave aside liner trade, you know, the ships that run on schedules and with lots of containers, and I mean they're not a problem, and they're shipping lines and they pay their debts and generally. But you know, there's 40 or 50, however many thousand, 40, 50 or 60,000 tramp. I call them tramp. They're just ships to hire, and they're all owned in now. Most of them are in one ship companies by people who have transferable shares in registries all around the world. You try getting your money in, and try and run. Imagine as you're flying in over Singapore and you see that harbour or Hong Kong harbour, and you see those. You can't count them. You can't. I remember trying once. You can't count them. Imagine that port running on COD. I mean, really? No. I mean, theoretically you could electronic transfer, and you know, but really? And that's what the maritime security regime does. You know, bunker suppliers or people who did this or people who did that on the ship, and they want to be paid.
So no, is the short answer. I don't think it would be possible. I mean, and this is one of the things, you know, I've spent my career as a maritime lawyer, and particularly when talking to constitutional lawyers in the United States, I constantly have to defend the idea that, well, ships are different. There's a famous article, ships are different. And they say, well, why are ships different? Well, part of the answer is they always have been. Historically, they always have been. That's not really a good answer in itself. The fact that something has always been so isn't a good reason for continuing it to be so. But well, I repeat what I said earlier on, which is if it were not the way it is, if there were not the Admiralty procedures that we have, there would have to be something else. There would have to be something
You've
else.
both alluded to the constitutional differences. Martin, would you like to go first?
Oh,
and
Lord,
talk
yes.
About
Well,
jurisdiction as
yeah,
adopted
yes.
in the US.
This is a small war that I often have to fight with constitutional lawyers and among my colleagues. But to make it as simple as I can, there is this fairly fundamental notion that federal courts cannot make judge-made law in the United States. There is no such thing as federal common law, except in the Admiralty jurisdiction, right? Because judges do make judge-made law, general maritime law, in the Admiralty jurisdiction. And my constitutional law colleagues go, well, why? What's the difference? Well, like, well, why? And the answer is that, and they hate this, but the answer is that it is conceived of, maritime law is conceived of as a transnational body of law that existed before the country existed and was adopted as part, it's actually mentioned in the Constitution, Admiralty and maritime law. One of the, and this sounds like a digression, but one of the most famous lines that Oliver Wendell Holmes ever wrote, it's a famous line, was the law is not a brooding omnipresence in the sky. I don't know whether you've all heard this expression before, but what he was doing was actually complaining about maritime law in a case called the Western Maid, because the notion that that Holmes was complaining about was that the law is not a brooding omnipresence in the sky, it is the command of a sovereign, right? Mm-hmm. And he was saying, this thing that you all say that existed before the country existed, maritime law out there, transnational body of rules, not the rule of a sovereign, he says that's not law, right? To which the answer that the Constitution gives is, yes, it is. Yes, it is. And so there is constitutional recognition of the fact that the United States adopted this body of rules and continues to develop this body of rules in a way that it cannot do in any other field except maritime law.
And then there are a number of cases from as early as I think 20s and John Marshall, and I once said, you know, in dealing with those views of those really positive 19th century positivist views of the man who was on, you know, took a few bullets in the Civil War and was lucky to survive. He had a pretty brutish and simple, you know, what is this? But they all said, and Marshall said, and Taney and Bradley, that it's not, and this is the point. If those of you who remember my fairly trenchant Deathridge a few years ago, 3 years ago, about Diplock and Denning. Diplock misrepresenting Denning quite badly. Denning never said it was a binding law of the world, nor did Marshall, nor did Bradley. They said it was a body of common principle, sufficiently coherent to be able to be called law, to be adopted and adapted by individual countries as they saw fit. And there's a marvelous expression of it by Jackson after coming back from the war trials. Talked about this, that it's not giving up of sovereignty, it's not some brooding omnipresence binding even the great United States of America, as Holmes said. It's a really interesting jurisprudential conception. It's a body of principle that's not binding, but there to be adopted and adapted. And if you go back to what I said earlier, growing out of the activity of people over millennia from different places. Of course, they all have notions of salvage, of notions of general average, saving the vessel by throwing the heavy stuff over, the rest who are saved have to contribute. All those things are principles that that when it came to dealing with the Titanic and the wreck and who had the court, the circuit court, reached to those general principles to say that applies. And that's why it's fascinating, and that's why it's harmony, not uniformity with that level, and uniformity when you get to conventions.
Right, and that's why at one level, the answer that is at some level unsatisfactory, it has always been thus. That's never really a good answer, except that in this context, it is a good answer because it has ever been thus, because this body of principles, not binding laws, as James said, but this body of principles has developed over thousands of years of people engaged in the activity. Now, James said earlier on that this is not the law of a people, a physical jurisdiction. It's the law of an activity, and that's why the antiquity of the maritime law principles is so important.
And that constitution, and now we, as it were, come to Australia, because what you had by the time those people who formed the constitution were deliberate, they knew about it. They were a number of them at least, were very, very well versed in American constitutional history. And one of the pieces of constitutional history that they were well versed in was Article 3, Rule 2, which is in identical terms, other than the word matter, using the word case for our matter, as 76.3. It only gave jurisdiction. But what the courts, at least from the 1850s, said in the United States was, you cannot have federal judges making the law and administering the law without congressional control on maritime law. And so there was an implication into the Constitution by, in effect, the equivalent of 5139, of you have to have Congress having this power if the judges can do it. Mm-hmm. And so there was just no debate about this, and once it had been set down, it was just driven, into the fabric of, and the first great constitutional textbook in Australia after the Federation said the same will happen here. I mean, we've got the identical, and it came up in the Calibia, just a Seafarers Workers' Compensation Act. And it was and the High Court, in the most offhand way, just didn't give any reason, just offhand said, this is rubbish, we're not going to follow it. And they said, maritime law is for the Imperial Parliament. Now, notwithstanding Justice Gummow, in later cases, in a superb judgment in Shinkobi Maru at first instance, saying this has to be looked at. No one's ever looked at it again. And and this is one of our problems. Without this, where is the constitutional power in the Commonwealth Parliament for maritime law? And, it's corporations, interstate trade and commerce. And even in interstate trade and commerce, we've hobbled ourselves because we use the kind of terrene, land-based notion of, well, what's happening? What's going on? What's the activity? What's the ship doing? Is the ship going to Brisbane or is it just going to Lismore? Whereas the American courts they looked at the water and they say, is that water capable of supporting interstate and overseas trade and commerce? If so, that's it. And partly, and it's the other jurisprudential thing I find fascinating is that it shows you the deep considerations of where law comes from in a particular place. Not to be too colourful, but the Americans wrenched their independence from out of the bloodied hand of an imperial power. And it was theirs, and that was it. And they had these great river systems, and, you know, no, and they were developing the country and moving, and this was national. This was an Atlantic-facing power. We were a federated colony subservient to imperial power, and it has always, it's just gone through in our frame of reference to how we think about 76.3 compared to Article 3.
Right. I mean, you read those, the Supreme Court decisions about the scope of the Admiralty jurisdiction and extending to the navigable rivers, and they have no qualms about saying that the English view is inappropriate for the American context.
That's right.
And we've done our own thing. By the way, I mean, as you can tell from my accent and my heritage, I'm not an American, but it's 2 days away. Will be the 250th anniversary of that Declaration of Independence. And man, the Declaration of Independence is apparent in those Supreme Court decisions, which it isn't in Australia, which I think is your point. Yeah.
And it's never, and if I may say it again, notwithstanding they were about as broad a hints as Justice Gummo would ever make. You know, one of the finest of our judges in the last 50 years, I think. I've never really spoken to him personally about this, but I will expect what he thinks. But
what about the idiosyncratic aspects of Australian and South African maritime law that have disjointed somewhat the harmony that we hope for in maritime law? Things like the associated ship arrest in South Africa, our peculiar view of COGSA, the notion of security arrest, our version of wrongful arrest.
Well, in a way, I mean, those are, this may seem like an evasive answer, but those are different ways of looking at the same questions, right? Because every country has to face the same question about what exactly can you seize in order to establish jurisdiction. I have actually always been quite in favor of the South African view about associated ship arrest, because it seems to shed this curious infatuation with corporate personality that every other jurisdiction seems to still be wedded to, right? That you set up a series of one-ship companies and, oh, well, you can't arrest this other ship because it's owned by a different company than this ship. So, I mean, the idiosyncratic South African approach is about ship arrest, but I mean, attachment of property. In the United States, it's possible to attach any property, tangible or intangible. That's what the rule says, tangible or intangible. So the ability to seize property to establish jurisdiction in an Admiralty case is not confined to ships in the United States. It can be anything, including bank accounts. Well, particularly bank accounts, actually. So although those are distinctly different approaches, they're just different answers to the same question.
And that's an example of what I was saying earlier, that people know these things. I mean, apart from the fact that I think it was Australia and even England, you were pushing in 1999, prior to 1999, for something like that, and it didn't get through because one-ship companies are too too important to lose for some people. But take the different view of Singapore and Australia to security arrest. Here, you do it all the time. You say, a number of times as a judge, you say, "Oh, fantastic! Look at this case we've got. It's a charter part, it's a salvage case." But no. And they don't. There's an arbitration somewhere. They're not going to bring that to you. They just want the money in the court's bank account or the P&I Club letter. And I think that's a good thing. It's not an abusive process. It's the world maritime security regime working.
But in Singapore, it is regarded.
I
as
know,
an
and I
abusive
just think
process.
that's mad. With great respect. I mean, it's because
mad.
well,
Anybody here from Singapore?
No,
Right?
no, it's not mad. I shouldn't put it that way. No. But if you conceive of it as not jurisdictional, but you conceive that we are all maritime courts around the world are part of a maritime security regime which is interconnected, then the only chance you've got, if you grab the bulk carrier here and you put up the security and off you go. And, you can stay the in personam case as, China or Europe is the obvious and only place, and it's inappropriate to have two cases going, but you can keep the security here. They can hear the case, and the money, whether it's a top up of the limitation fund or whether it's just a few $1 million, then you've got your money here.
I mean, I think it must be said that Singapore is a bit of an outlier in regarding security arrest as unacceptable. I think most countries take the view that seizing a vessel or whatever other property, as you can in the US, for example, just to get security for a dispute that will be decided, the merits of which will be decided elsewhere.
In an arbitration.
That's just an example, as you said, of the international, comity of courts assisting one another.
And assisting arbitration too.
Which in its way, it is an assistance to, the fluidity of international trade, I guess. But,
yeah.
Have you got any closer to persuading the insolvency practitioners that what we do is not heresy?
No. In a word, no. No.
Yeah.
Right.
Some of you will remember I made a particular American insolvency judge extremely angry. It was in this room, I think, or somewhere in this building. But that's another story. We haven't got much time to. The interface between that maritime security regime, where you can turn unsecured claims into secured claims, as long as the claims maritime and the properties maritime, then intersects with the broader, the groups, they're all becoming insolvent, and Comey's under the model law, cross-border insolvency.
But the way that maritime law approaches security, priority rather, sorry. Not surprisingly, because I'm a maritime lawyer, it seems to me to make more sense, right? That it actually gives priority over involuntary creditors over voluntary creditors, right? So if my ship collides with your ship and you've got $1 million claim against mine, well, that takes priority over the people to whom I have given security, right? That's a really sensible approach, I think, that to prefer involuntary creditors to voluntary creditors, anathema to bankruptcy lawyers.
That's right. And the way different social race, and this is the interesting thing, in that although it's a law of activity and it's harmonic, but as the great American judge said, each nation gets to think to say what's important to it in its maritime law, and in some countries, it won't come as a surprise, perhaps, that in the English system, at least for many years, collisions were more important I think Crewe, or no, Crewe had a lien, but the collision lien was higher than the Crewe lien.
Yep.
Whereas in the People's Republic of China, the Crewe
Lien
lien
comes
is
above the concept.
up there. Now, then that was just an example of social values of a particular place leading to a different hierarchy, because some countries have placed greater value on, have more ships, and therefore collisions are more important, or whatever. But I do think, we were talking about it, or writing about it, and I do think that there might be some utility in being a bit more precise about priorities. But the reality is, there have been 3 maritime lien and mortgage conventions, and no one can agree on anything.
It is a peculiarity. I mean, we talked about this before. It's a peculiarity of the fact that priorities are so important in the whole process of security and ship arrest, and yet there is no canonical list of priorities.
But it comes back to the equitable concepts that you were talking about at the beginning. And
I mean, because there is the power. I don't know how often it's exercised, but there is the power. I mean, well, I was going to say you two, but you and not and some of you as well have the power to alter the list of priorities if you think it appropriate,
And
which is, I mean, I always find that slightly strange. But
but to go back to my talking about the hobbled nature of Australian maritime law, I mean, because if we don't, there's a real issue about whether the Parliament's got the authority to do it.
Right. Where's the list?
Because we don't have. Yeah. I mean, and the great irony is, until in Melbourne in 1898, the penultimate version, they had maritime law in 51. And they said, oh, I don't need it there. Why don't we put it in 98 where Trade and Commerce is talked about? Now, whether they had in mind the water notion, but they put it in Trade and Commerce, and they took it out of 51.
now the CMI has been working on the Lex Maritima statement of principles that it hopes will guide nations all around the world as to how they might apply maritime law principles more harmoniously. Have you got any thoughts about that as a project?
Yeah. I've always been slightly baffled by that project, because it seems to me to be, I mean, it's a very worthy effort to kind of re-emphasize what has alwa't been the case about maritime law, right? And so the idea that there is this lex maritima, the maritime law has always been. That's what we've been saying, in the whole of the rest of this conversation. And so to try now to, well, it's not an attempt to codify it.
Yeah, but that's the problem.
Yeah,
that's the problem. I think. Then there's this, especially amongst some of us, and I mean, and Futrell knows what I'm talking about now. Not because he's the problem, because he and I have been reading the same books about this. I mean, there is a tendency, especially amongst lawyers, and it's a good tendency quite often. To a point, it's often a really good tendency. Can't we be clearer? Can't we define this? And there's this kind of urge for certainty, an urge for precision. And if you just keep writing, it'll become clearer, and an urge for and that's what I was saying about uniformity. I mean, uniformity can be a bad distraction, because we've got to get this uniform. Well, no, you don't necessarily. If people understand At what level is there agreement about the underlying principle? And at what level is there debate about how that should be expressed? Well, is it worth doing that? Because will it just either hide the problem or create a conflict, and you've got two principles?
Right. I mean, that's
You know,
why I find
How are we doing this?
I find it a little baffling that CMI should have undertaken this, because, I mean, the CMI's whole raison d'etre, here we go in French again, raison d'etre, is the uniformity. But they, of all people, know that complete uniformity among all the many different countries that are represented
gonna
at CMI is impossible. So, what exactly
Are we doing? with
is it supposed to produce?
But there's a project, for instance, at the moment on marine insurance
Mhm.
at CMI, and it's just started, and it's going to be interesting to see what its aims really are. I mean, I think that initially it's just to see what and interrogate all the bodies that should be interrogated, maritime law associations and the like, about what is worth expressing commonly, as it were. But I think this problem of searching for uniformity when it's not realistic distracts you from making things as perhaps some changes to express common principles that are harmonious, from which each country adopts and adapts, to use Marshall's expression.
Okay, now can I ask a question? I feel like we can't have this conversation. James and I can't have this conversation without asking about personification of the vessel, right? Now, this is something that I think we do agree upon, but most of the world does not, or at least the common law world outside of the United States does not, except there are, well, principally your judgments, but not only, fairly strong indications of the notion of personification of the vessel as the person who is liable. So tell me what you think about personification, because you know what I think.
Yeah, I mean,
She is
you know
the
what they call
countries of Ireland.
you know what they call the Indian grace in London Bar now?
What do they call it?
The Indian disgrace.
Ah,
Fictions are, I mean, our whole commercial life around the world is built on a fiction of corporate existence.
Yeah,
as
exactly,
opposed-
right?
I mean,
it's
they even allow them to make,
freedom of speech. Give
Freedom of
as much
speech.
money as you like to a
Right, yeah.
political campaign. Yeah,
Anyway,
corporations have. Yeah.
So
right.
fictions are useful. We live with fictions,
Yeah.
because if we didn't, the law wouldn't be able to do certain things. And the notion of personification, to the extent that the ship is liable, I mean, yes, it's almost a medieval, break the axe and bury it, or burn it or something, because it's the murder weapon. But it's more subtle than that. And it has its place. And to the extent that in its modern incarnation in the House of Lords in 1998 saw the fiction of in rem action against the ship, because you need that degree of personification to have in rem claims. It's a claim against the ship. And it's separate and it doesn't merge. And it's the foundation of allowing people to have one go against the ship for their debt. If they don't get anything because ship's not worth anything, or there are higher order claimants, they haven't mucked up their in personam claim. And the Americans just have it, as the civilians did in England. that the lien attaching to the ship was the mark of the
liability of
NREM,
the ship.
was the liability of the ship.
And
And it
the-
makes it a lot easier.
Right. Oh, and I just think more sensibly so, right?
Why?
Because as we all know, there are all kinds of different chartering arrangements about who's operating
Why
what
should-
in
why
relation
should-
to the ship. Why should the claimant have to figure out who's responsible for what? My view has always been, okay, take your money out of the ship and let them sort out,
Precisely.
where the loss should ultimately reside.
But-
And that can so easily be done with the US doctrine of personification. I mean, I don't want to sound like I'm an apologist for US maritime law, but this is the one genius, I think, of the US position.
The only difficulty is that the human rights lawyers have got onto it and are now bringing claims for breach of the human right of the ship.
Ah, right. Right.
But
It's not that personified. It is a fiction. It is a fiction, after all, right? But it's like corporate personality. I mean, when people say it's crazy that the ship can be liable and the ship owner is not, I think, well, why is that any different from corporate personality, where the corporation is liable and its owners are not?
But it also throws up. And we're never going to go back to the Bulgari and say, well, now Australia is just everything's a lien. But that said, if you don't have personification, you go through this absurd, who's the owner here? Who's the owner there? Oh, well, yes, there was one ship company, but let's have a look at all the directors' resolutions, because who's really, I mean, the one thing that could be done, I would have thought constitutionally, because it would be as to jurisdiction, would be to but you need another convention, I guess, but move away from this notion of owner, or at least domestically move away from the absurdity of the Maria Luisa. There's this diver badly injured and couldn't sue the owner because it wasn't the owner, because it was held under a discretionary trust and it hadn't yet vested, in that way. And there was only one. Oh, really?
I said,
and this man went without money out of
this
the ship.
relates to what I was saying earlier on about the South African thing. I mean, I just don't understand. Well, I do understand, but I have no patience for, perhaps is a better way of putting it, the infatuation with the notion of corporate personality, right? Which is a useful fiction as well, but it's a fiction too, right? So why are we so infatuated?
Keep doing that.
Keep doing it.
We've almost come to the end of the hour. I think it would be cruel not to give you all an opportunity at least to ask one or two questions.
Of James.
Or of Martin.
No.
Can I invite anybody who would like to ask a question to do so? Yes. Could you perhaps indicate who you are?
Hello, my name's Swapnik. I've maybe met some of you who are here already. Thank you for your comments. That was extraordinarily interesting discussion. One point that I wonder if you could touch on a little bit more. You've obviously spoken lots about the sort of internationally harmonious nature of maritime law, but I wonder if you can speak a little bit more about the fissures across jurisdictions, because to me, for example, if one thinks about the law relating to, say, bills of lading or cargo claims, the superimposition of our common law of contract onto that fundamentally mercantile activity might seem very strange to the civilian lawyer or to the, trader who's dealing with these things every day. And yet, ultimately that's what determines their substantive rights and obligations.
You want to do that one?
No, you got it.
No, I mean, I thanks. Well, this may or may not be a response to your question, but what struck me when you talked about Fisher's differences between the approaches in different countries, at the crudest level, what that ends up doing with the freedom that we've described before about this international system of security, maritime security, is forum shopping, right? You can go to the place where the law is most favorable. Well, the plaintiff, can go to the place that's most favorable to its position, right? Now, whether the case will ultimately be decided on the merits in that place, common law or civil law, will depend. Well, civil law countries will keep the case because they don't have a doctrine of foreign non-convenience, right? Common law countries might, but the differences, the fissures as you describe them between the different approaches, that's just fodder for forum shopping. And as far as I'm concerned, there's nothing wrong with that. There's a famous article called "What's Wrong with Forum Shopping?" Because from a lawyer's point of view, that's actually what you're supposed to be doing for your client, right? To finding the most favorable outcome. So there will inevitably be, because there must be, differences between different approaches in different countries. And the ease of forum shopping in the maritime jurisdiction is perhaps one of the most distinctive differences from non-maritime cases. I don't know if that addressed.
And the only thing I would add, I agree with that. The only thing I would add is when I've been using the word harmonious, I don't mean uniformity light. I mean, there are differences, but there's a kind of harmony in the differences. People know what's going on. It's not irrational. It's not capricious. It all comes from the same mold, but people do things differently because of their own national interests, because of their own histories, because of the commerce in those places. And there are fissures and there are civilian, but broadly speaking, the difference between, I mean, the civilians have a law of contract. It doesn't come as a surprise to them about what is this thing called contract. And the most important thing is understanding, if you're the stranger, if you're the foreign master or the foreign merchant, or you're in a place and you go, what is happening here? And you go, oh, and mostly in shipping and international trade, they know what's happening. Oh, we're here, we're in China, or we're in India, or in Australia. We know what, and that's this kind of certainty that harmony brings, that it's not, I know exactly what's going to happen, but I know what I'm dealing with here, and I know what the rules are generally, and I know whether the place is reliable.
This may be an immodest way of making the same point, but I've taught maritime law in 5 different countries, and the rules are either the same or they're different. Right?
Yeah.
It sounds like a dumb thing to say, but the questions are all the same, right? And so there is a great deal of, I mean, it's not that difficult to shift from one jurisdiction to another. The rules are either going to be the same or they're going to be different, but you know what you know what the questions are, right?
And a couple of good colleagues that you all know, Peter McQueen and others. We taught maritime law for 15 years in Sydney University, then Sarah's University, but we didn't teach Australian maritime law. We just taught it we just had conventions, Chinese Maritime Code, you know, the Norwegian, the Scandinavian Maritime Code, and you just taught, and you walk through the problems. And this is how and so the idea was, when those people finished, if they were interested and went on to study, they go, oh, hang on, this is the way the Swedes do it. Oh, hang on, this is the way the Americans do it. And that's what commercial people are like. I mean, law is not the province of lawyers in this game. It's the commercial people who.
Now, as I'm sure you've worked out, these two could sit here and
Aye.
chat all night about these topics. But I think we should call the formal part of the proceedings to a close. It's been a fascinating discussion. I hope you've all learned something from it. And I hope that it's been a fitting start to the 50th anniversary celebrations, that the most important NPA went first. It was not just because it's alphabetically first.
It's because it was this NPA was started in 2005. That's why.
Yeah. All right. So would you please join me in thanking James Allsop and Martin Davis?
Well done, John.
And if anyone says anything to a Singapore judge about what I said,
Yes.
before I say it to them and apologise, you'll be in real trouble.
Please join us for refreshments outside.